Pardon the interruption. We had Chelsea Tremble on the line, and we had two other people dialing in. One moment, please.
Hi, Chelsea.
Hello there.
So far, just us. So far, no public.
Yeah.
Just us and Joe Vicnicki.
Yeah. Hey, Joe.
Pardon the interruption. We had Taylor Norham on the line, and we had three more dialing in. I'll be right back.
Thank you. Welcome, Taylor.
Welcome.
Yep, hello.
Good.
Pardon the interruption. We have Sarah Heidemann on the line, and we have three more dialing in. I'll be right back.
Thank you. Welcome, Sarah.
Hi, Debbie.
Pardon the interruption. We have Jeff Nietzsche on the line, and we have two more dialing in. I'll be right back.
Welcome, Jeff.
Thanks, Debbie. Pardon the interruption. We have Brandy Morrow on the line, and we have one more speaker dialing in. One moment, please.
Welcome, Brandy.
Hello.
And pardon the interruption. We have James Kerr on the line.
Thank you. Welcome, Jim.
Yeah, thanks. We have two participants dialing in. Would you like me to give you a standby message in the meantime, or you ready to begin?
Let's see who's calling Mario, and then we will get started. I'm hoping one of them is Bob Lynn, or some of the last assembly members to call in.
No problem. Just one moment.
Bob's here.
I'm here. Oh, you're here already, so you have a full assembly. All right, Bob, I wasn't on when you called in. So, Mario, I guess, can you start the countdown?
Certainly, yes. I'll do the usual countdown. I'll do 5, 4, 3, 2, 1 will be silence, and that will be your cue to begin the meeting, okay?
Sounds good. Thank you.
Thank you so much. So we're live in 5, 4, 3.
Okay, we're going to call this community discussion to order. Today is not a regular assembly meeting like it was posted on our agenda, but that was just the format that we've used. So this is just a community discussion, and we don't need to necessarily have a quorum, but we do. We have all assembly members in attendance. We have a moderator today that will run the meeting, Sarah Fine, and we decided that she will be reading the questions and the answers that have been submitted to the Assembly for this meeting today. And the public can call in today, and the number for that call-in is 800-954-0633. And there will be a 5-minute limit on the testimony. And with that being said, I will turn the discussion over to Sarah Fine. Thank you, Sarah.
Thank you, Mary Jensen. Good evening, Petersburg, and welcome to our community discussion about proposed Ordinance 2020-19. It's a permanent ordinance defining and preparing for civil emergencies in Petersburg. We're here live at the Petersburg Borough Assembly Chambers in our Petersburg Municipal Building on Nordic Drive and on the radio at KFSK. My name is Sarah Fine, and I'll be your moderator this evening. With us tonight on the air are a selection of knowledgeable Petersburg public servants. Some have some brief presentations for you all, so we can all be prepared to discuss the finer points of proposed Ordinance 2020-19 and what it means for Petersburg. Our presenters this evening are our Borough Attorney, Sarah Heidemann, our Borough Emergencies Operations Center Operations Chief, Sandy Dixon, and our Borough EOC Incident Commander, Carl Hagerman. Also present and available are our Borough Manager, Steve Giesbrecht, and our Petersburg Medical Center Incident Commander, Phil Hofstetter, and our Borough Health Officer, Dr. Mark Tusilla, may be available for some questions. Also with us tonight are our Borough Clerk, Deborah Thompson, who's keeping track of our audio, who's calling in while we're live on the radio and reporting for the archive. Of course, the Petersburg community, who are listening in at KFSK and calling in on the public comment hotline, and our Borough Assembly, as Mayor Jensen said. We will vote on this proposed ordinance on Monday, September 21st. Before we jump in, I wanted to give a brief preview of how this evening will play out. There will be 3 stages. Stage 1, our 3 knowledgeable public servants will give factual presentations about the proposed civil emergency ordinance. First, Sandy Dixon, our Petersburg Borough EOC Operations Chief, will give a general outline of our incident command system and how it's been working in Petersburg. Then Sarah Heidemann, our Borough Attorney, will go through our local emergency ordinances and the Alaska state statute and explain why Petersburg needs an updated local ordinance for handling both present and future emergencies. And finally, Carl Hagerman, our Petersburg Borough EOC Incident Commander, will give a general outline of how the borough has used emergency ordinances during this pandemic and why Petersburg needs a permanent civil emergency ordinance. So that's stage 1. Stage 2, I will read the questions and answers that were submitted in advance and responded to by our borough staff. Finally, stage 3 is the time for public comment and questions. As Mayor Jensen said, the same rules apply here as do to assembly meetings. First, to start off our presentations, we have Borough EOC Operations Chief Sandy Dixon to run through how our incident command system works. I'll turn it over to Sandy.
Good afternoon. I will be giving a little background on the incident command system, so the history, how it was developed, and then why we use it. I apologize, it's a little jumbly because it's not the best topic to try to do a presentation for. It is more intended for people to actually take the courses and then practice what they learned. So basically the background of the incident command system, also known as the ICS system, is in order to safely and effectively manage an incident, we must have some type of standardized management. As many safety professionals know, someone else has likely had a similar problem and has come up with an answer which we can simply borrow and apply to our situation. Such is the case with handling emergencies. Professionals in the fire service manage emergency situations of all types, including fires, multiple casualty events, natural and man-made disasters, hazardous materials releases, and even responses to terrorist attacks. In In the event of a disaster, leadership for emergency management is assumed and maintained by local government officials. However, due to the differences between structures of many state, federal, and other response agencies involved in response and recovery efforts, a standardized system for communication, command, and control is required. The Incident Command System is a standardized hierarchy structure that allows for a cooperative response by multiple agencies, both within and outside of government, to organize and coordinate response activities without compromising the decision-making authority of local command. ICS ensures that most pressing needs are met and that the precious resources are used without duplication or waste. A little history: the Incident Command System was developed in the 1970s by an interagency group in Southern California called FireScope. That stands for Firefighting Resources of Southern California Organized for Potential Emergencies. They set out to develop two interrelated yet independent systems for managing wildland fires. In the aftermath of a devastating wildfire in California, where 16 deaths occurred, the loss of 700 structures due to the fire, and over 500,000 acres were burned, there were numerous problems with communication and coordination that hampered their effectiveness. So this multi-agency group, consisting of the California Department of Forestry, the Governor's Office of Emergency Management, the Los Angeles, Ventura, and Santa Barbara County Fire Departments, and the LA City Fire Department, with the U.S. Forest Service, made up this integrated resource called FireScope. In the early 80s, that ICS system was expanded to use in non-fire incidences. This is what we use today. It was likely recognized as a system that could help public safety responders provide effective and coordinated incident management for a wide range of situations, including floods, hazardous materials accidents, earthquakes, and aircraft crashes. It was flexible enough to manage catastrophic incidences involving thousands of emergency response and management personnel. In 2004, the National Incident Management System was developed by the Department of Homeland Security. NIMS, the National Incident Management System, also known as NIMS, has enabled responders at all jurisdiction levels and across all disciplines to work together more effectively and efficiently. It is a management system used by federal, state, and local governments to manage emergencies in the United States. As of 2006, all federal funding for state, local, and tribal preparedness grants is tied to compliance with NIMS and is mandated by the Federal Emergency Management Agency, also known as FEMA. One of the most important best practices that has been incorporated into the National Incident Management System is the Incident Command System, the ICS system. It is a standard, on-scene, all-hazard incident management system already in use by the firefighters, again, hazardous materials teams, rescues, and emergency medical teams. The ICS system has been established by the NIMS as the standardized incident organization structure for management of all incidences. Therefore, to be compliant with NIMS directive, states and local governments must institutionalize the use of ICS across the entire response. In order to be NIMS compliant and eligible for federal monies, the Petersburg Borough, formerly the City of Petersburg, passed and approved Resolution 1797 on June 5, 2006, mandating the use of the National Incident Management System. Again, the NIMS provides a consistent, flexible, and adjustable national framework which government and private entities at all levels can work together to manage domestic incidents, regardless of their cause, size, location, or complexity. This flexibility allows across all phases of incident management for prevention, preparedness, response, recovery, and mitigation. So why do we do this? The purpose of this system is to ensure that most pressing needs are met and that precious resources are used without duplication and waste. The primary role for the ICS system is to establish planning and management functions for responding partners to work in coordinated and systematic approach. In the event of a disaster, leadership for emergency management is assumed and maintained by local government officials. However, due to differences between structures of many state, federal, and other response agencies involved in response and recovery efforts, a standardized system of communication, command, and control is required. The ICS system is that standardized hierarchy structure that allows for a cooperative response by multiple agencies, both within and outside of government. to organize and coordinate response activities, again, without compromising the decision-making authority of local command. ICS ensures that most pressing needs are met and that precious resources are used without duplication and waste. Obviously, that's important. I keep saying it. Command must be established for all incidents. We can have a single incident command or a unified command. Single incident command is a single agency which controls the resources and operations. Think of it like the fire service if there were a fire call. The fire department would be that single incident command. A unified command is where multiple agencies involved, such as fire, police, public works, maybe the U.S. Coast Guard, or Petersburg Medical Center in this case. Several agencies work independently but cooperatively rather than one agency exercising control over the others. It recognizes that large-scale incidences tend to be more complex and that the right agency must take the lead at the right time, with command officers from all agencies cooperating. An incident commander is established. The incident commander is the person who assumes responsibility for the incident management. This individual stays in the position of command unless that function is transferred to another person or until the incident is brought to conclusion. The incident commander sets priorities and defines the organization of the incident response teams and the overall incident action plan. The role of the incident commander may be assumed by anyone who has the training and knowledge for the position. Who designates the incident commander? The jurisdiction or organization with primary responsibilities for the incident designates the incident commander and the process for transferring command. The incident commander is the only one person that is always staffed in the ICS application. In Chapter 3 of the Petersburg Municipal Code, it states that the incident commander is the borough manager or the person designated by the manager to serve in that capacity. Once an incident commander is in place, they must consider how large or small their command staff should be. Typically, this is determined by the size and complexity of the event. On a small scale, the incident commander can assume the duties of all sections. However, on a larger scale incident, the structure will need to be expanded. The ICS system recognizes that the manageable span of control is 3 to 7 people. As the incident becomes more complex, the number of people in span of control become too large for one person to effectively manage. At this point, the command designates people to handle the specific functions needed to manage the operation. In other words, an operations section chief, planning section chief, logistics section chief, or finance section chief. Getting organized early and aggressively is very important. You have to plan. You have to have a plan. A common mistake is to underestimate the resources that will be needed. So we've all heard the story of go big, go early, or go early, go big, because we don't want to be caught. So the role of the incident command system is to establish planning and management functions for responding partners to work in coordinated and systematic approach. These functions can include using common terminology, integrating communication media, creating a unified command structure, coordinating resource management and allocations, and planning. The function of ICS includes assigning one central coordinator. Again, that is the incident commander, to manage response activities by assigning personnel, deploying equipment, obtaining additional resources, and coordinating with participating partners as needed. The incident commander delegates emergency management responsibilities as needed and thereby maintains necessary focus on the overall picture of the disaster situation. Often the incident commander is the local fire chief or commissioner. Again, that will depend on what the circumstance is. So in the ICS management system, you have, again, the command section, which is responsible for developing, directing, and maintaining communications and collaborations with multiple agencies on site, and working with local officials, the public, and the media to provide up-to-date information regarding the disaster. The operations section handles tactical operations, coordinates the command objectives, and organizes and directs all resources to the disaster site. They identify, assign, and supervise the resources needed to accomplish the incident objectives. The planning section provides the necessary information to the command center to develop the action plan that will accomplish the objectives. They also collect and evaluate information as it is made available. They track the resources. They logistics section provides personnel, equipment, and support for the command center. They handle the coordination of all services involved in the response, from locating rescue equipment to coordinating a response for volunteer organizations. So they order the resources. The finance section is responsible for accounting for funds used during the response and recovery aspect of the disaster. They monitor costs related to the incident and provide accounting analysis. So they procure and pay for resources. I'm almost done, sorry. So there are 8 core concepts, depending on which ICS program you look at, but common terminology, integrated communications, modular organization, unified command structure, manageable span of control, consolidated action plans, comprehensive resource management, and pre-designated incident facilities. So I'm not going to go into what those are, but those are kind of guiding principles on how to make the incident command system successful. So these are kind of my thoughts in summary. So the function of the incident command system includes assigning one central coordinator, the incident commander, to manage activities by assigning personnel, deploying equipment, obtaining additional resources, and coordinating with participating partners as needed. The incident commander delegates emergency management responsibilities as needed and thereby maintains necessary focus of the overall picture of the disaster. ICS can be used in a variety of situations, so not just in a pandemic or a fire or a flood, but it can be used for parades, large gatherings, terrorist attacks, any type of emergency. Again, it just is a management tool. People who say that the incident command system does not work is an opinion. It's not based on researched analysis. I would venture to say they do not understand the process of how the incident command system was created and why it is used as a system. The incident commander is the driver, and the incident management is done by objective. That is the engine. Incident command system gives us the ability to work with other agencies without duplicating efforts. It gives us a systematic process and system to more efficiently protect life and property, which are usually our missions in life. It is a flexible system to work in all incidents, as I stated. Standardized to provide a coordinated, efficient response to each incident. If you don't know who is in charge, then it doesn't matter how good your incident command system is because it will still be a mess. Individuals trying to run the show without a clear leader just causes chaos. That is why we appoint or assign an incident commander to emergencies or large events. It helps establish and meet priorities. Again, our priorities are life, safety, incident stabilization, and property preservation. They are listed in order, but all these priorities can be taken care of simultaneously. We need to set objectives. When we set objectives, that equals the incident command system. Our objectives are what we do. Under that are strategies. How are we going to how are we going to accomplish our objectives? And then tactics are what are the resources that we need to accomplish and fulfill the strategies to meet our objectives. So the tactics, refer to personnel, equipment, tools, etc. The ICS system gives us an opportunity to enter into mutual aid agreements. Those written agreements are among agencies and or jurisdictions that will assist one another as required. It involves 2 or more public agencies representing one or more governmental level, state or local. The size and complexity of an incident command structure, again, will depend on the size of the incident life cycle, whether we expand or contract our structure. The incident type determines the responding agency with functional responsibilities for distinct aspect and incident response, control, and removal. The Incident Command System is a subset of the National Incident Management System designed specifically for management of multiple casualty incidents, again, which we have directive from the federal government to be compliant. Lastly, I would say that to remember that each function begins with people. Each function in the ICS structure begins with people, not a specific individual. That seems to be a concern in the community, that they think certain people have too much power. It is a position, not a person. Any person trained in the incident command should be able to fill any functional needed position. It is not about power. ICS should be should be thought of as a friend. And if anyone would like more information on this, there are ICS courses free online with FEMA. So that is all I have, and I apologize if people are sleeping.
Thank you, Sandy. Our next presentation is by Borough Attorney Sarah Heidemann about how the state and local emergency rules work and how proposed Ordinance 2020-19 would help Petersburg. I'll turn it over to Sarah.
Thank you, Sarah. I'm going to go through the proposed ordinance section by section to discuss the differences between existing Chapter 372 of the Borough Code and the proposed revisions. Before we do that, I'd like to briefly discuss why the Borough is considering changing the existing language of Chapter 372. Why is this ordinance necessary? So a couple of things to note here. From an administrative standpoint, Chapter 372 has not yet been moved over to the Borough Code from the old City Code. Since Borough formation, Borough staff and the Assembly have been going through the process of considering and moving over each chapter from the City Code to the Borough Code, and this one had not yet been considered by the Assembly. So under the circumstances of the current public health emergency, it was time to do that. From a substantive standpoint, the chapter had been adopted by the city about 15 years ago and hasn't been updated since. First, it refers to natural or man-made disasters without definition, and it's preferable to use the broader term of emergencies by tying it to the definition in Alaska statutes in the Alaska Disaster Act. Second, I thought it was important for the Borough Code to refer to the authority of the borough manager to issue an emergency proclamation under Alaska Statute 2623-140. While that authority is in state statute, you have to know it's there. It's much simpler for it to be set out in a local code book that folks deal with every day. Third, it appeared likely that emergency health orders or alerts may be issued in response to this pandemic, and the current code language does not have any procedures or safeguards in place for enactment of those orders. So while the Borough has the authority to issue emergency mandates, adding procedures for that issuance provides guidance for both the Assembly and for staff and residents. Fourth, the chapter should include language clarifying that orders issued under it would supersede other potentially conflicting borough ordinances so that you don't have inconsistency or ambiguity. What you want is clear direction. That language isn't in the current chapter. And lastly, it was important to update the code language as to violations. Code Section 372-040 currently establishes interference with emergency services and failure to follow rules that are issued pursuant to the chapter as a misdemeanor. I'll discuss this more in a few minutes, but the Borough has been transitioning to having violations of the code be primarily what are called minor offenses and not criminal misdemeanors. So also, before we move through the ordinance, let's briefly go over the authority of the Borough to both adopt this ordinance and to issue emergency orders and health mandates as contemplated under Section 060 of the proposed ordinance. So the Borough is what is called a Home Rule Borough. And under the Alaska Constitution, home rule cities and boroughs like Petersburg can exercise all legislative powers not prohibited by law or by charter. In other words, Petersburg doesn't need to look to state law to find its authorization to act. the Alaska Constitution specifically intended to provide for maximum local self-government and to override traditional restrictions on the exercise of local legislative authority that are often found outside. Additionally, the borough has what is termed police power to act in the interests of public safety and welfare. Rather confusingly, that term doesn't refer to the police department. It is just a term that has been used for decades to refer to the basic right of a state or local government to enact provisions that are necessary for the welfare of the public, where that right wasn't retained by the federal government. This covers a very wide swath of laws, including health and safety laws, zoning laws are another example. So the borough has authority to enact public health and emergency measures, provided that those measures do not violate its own charter or would impermissibly conflict with federal or state law. Okay, so with that short background, let's walk through Ordinance 2020-19. So the first section is Section 372.005, definitions. The existing chapter does not contain a definition section, and the intent here was to simply provide the necessary definitions for the chapter. There are only two real new definitions to the code. Civil emergency, which is defined by reference to the state disaster code, as I mentioned earlier, and the term curfew, since the borough code does not currently contain one, except for a curfew for minors that is found in Title 10. Section 372.010, intent and purpose. This sets out the chapter's intent to efficiently utilize and coordinate efforts in the event of a disaster. No substantive changes to the existing ordinance are being made here. The amendments to this section consist of changing city to borough and using the term emergency as now defined by reference to state statute. Section 372.020, Civil Emergency Preparedness and Emergency Services Office established. This section established the manager's office as the coordinating emergency preparedness and services office, and it appoints the manager as the incident commander for emergencies. The main changes here in this proposed ordinance are to, again, amend city to borough, and also to add in a reference to the incident commander position being designated by the borough manager rather than having to be the manager him or herself. The existing ordinance doesn't specifically provide for a designate to serve in that position, and it's prudent to make that provision since it may be necessary or desirable for that service to be delegated. Since original introduction of this ordinance, the Assembly amended the section to include the Assembly's ability to review and reject that designation. Section 372.030, emergency response. This section adopts the borough's emergency plan documents into the code. Again, there are no substantive changes here. The term city is being changed to borough, and the name of the emergency plan has been updated since it is now called the Borough Disaster Response Plan, as discussed a little earlier by Sandy. Section 372.040, authority to issue emergency proclamation. This is a new section which sets out the authority of the borough manager to issue a proclamation of a local emergency, which is effective for 7 days unless ratified or earlier terminated by the Assembly. As I mentioned a few minutes ago, this authority is specifically set out in state statute, as is the duration of a proclamation without Assembly ratification. I do think it is important to have it in the Borough Code Book so that it is more readily accessible. This section states that the proclamation would have the force of law. This is simply to make it clear that the proclamation can't be ignored or deemed ineffective simply because it is not found in the Borough Code Book or in the Borough Charter. To the extent that the proclamation would conflict with other laws, this section states that it would supersede them so as to not have conflicting ordinances impede or otherwise delay implementation of emergency response plans which are activated by the proclamation. Section 372.050, dissemination and posting of emergency proclamation. This again is a new section, and it requires the posting of the emergency proclamation or any emergency order issued thereafter under the chapter on the borough website, and that it be also sent to newspapers and radio stations. This is to ensure that residents receive notice as soon as possible, and also to meet the requirements of state law, which require that a proclamation be promptly publicized. Section 372.060, imposition or order during a period of emergency. This is also a new section. So once an emergency has been declared under Section 040, the borough manager, the incident commander, and the assembly could then issue emergency orders that they deem necessary to protect residents impacted by the disaster. If orders are issued by either the manager or the incident commander, the assembly can terminate those orders. And this ordinance also allows the assembly to meet on 8 hours notice rather than the usually required 24 hours notice for a special meeting. Paragraph A of this section lists a number of those potential mandates, which include ordering certain businesses to remain closed, prohibiting gatherings in excess of a certain number of people. Both of those have arisen in a lot of places, including within the state of Alaska in connection with the current pandemic. Ordering the evacuation of people from certain areas, and imposing a curfew. It does contain a catch-all in paragraph A8, simply because it's impossible to completely anticipate every situation and every order that might be necessary under the particular circumstances of an emergency. These orders would supersede conflicting borough law. Again, the intent is to provide clarity and to not require that an emergency order be reviewed against every single other ordinance of the borough in case of a potential conflict. I would note that it would not supersede conflicting federal or state law, where the exercise of authority has been prohibited to local governments, nor would it permit unconstitutional orders. Paragraph B of this section is a new provision not found in the current ordinance, and it is included to ensure that any temporary restrictions on rights have been considered in the issuance of these orders. Under this paragraph, orders are required to contain a statement of facts upon which the order is based, a statement that the party issuing the order believes that it is in the best interest of public safety and health, that the order be issued and that certain rights be temporarily restricted, and a statement that the order is intended to provide the least necessary restrictions on those rights. So, in other words, these requirements are to ensure that the order relates factually to the emergency that the borough is facing. The order directly addresses the emergency, and that the temporary restrictions resulting from these measures set out in the order have been considered, are deemed necessary for the public welfare, and are the least restrictive measures necessary to address the current threat. Paragraph E provides for issuance of health alerts when a mandate would not be required, and allows the use of all available borough resources, including personnel, to combat the emergency. The last section of the proposed ordinance is Section 372.070, compliance with official orders during period of emergency. The main modification to this section is to shift the penalties from misdemeanors to primarily what are called minor offenses. A minor offense cannot have jail time as a consequence of violation or a fine exceeding $1,000. Minor offenses, in short, just to explain them, are handled through issuing a ticket, and the police officer who issued the ticket appears in court to handle it if the ticket is challenged. If a misdemeanor is charged, it's handled differently. If the misdemeanor is a state crime, the state district attorney prosecutes it, and if the defendant cannot afford an attorney to defend the charge, the state would be required to provide and pay for an attorney for the defendant. But if the charge would relate only to a borough crime, that process would be the borough's responsibility. So a violation of Chapter 372 would be a borough violation, not a violation of a state statute or regulation. And accordingly, if charged as a misdemeanor, it would be the borough's responsibility to prosecute the case and the borough's responsibility to provide and pay for an attorney to defend the individual charged if he or she couldn't afford one. So in general, as part of the process that I discussed earlier, moving the city code over into the borough code, violations of the code have largely been changed from misdemeanors to minor offenses. Now that doesn't mean that more serious crimes aren't charged in the borough. It just means that they are just charged typically as state offenses. So that, in brief, is a summary of the proposed changes to Chapter 372. So at this point, I will pass this back to the moderator and on to Carl.
Thank you, Sarah. Our final presentation is by Borough EOC Incident Commander Carl Hagerman about how the Incident Command team has navigated Petersburg through the COVID-19 pandemic and how proposed Ordinance 2020-19 would help Petersburg navigate future emergencies too. I'll turn it over to Carl.
Thanks, Sarah. So I want to start with basically a restatement of Chapter 3.72.010. I think it's the intent and purpose of the emergency ordinance, and I think it bears repeating. And it states, it is the intent and purpose of this chapter to provide for the efficient utilization of the borough's personnel, facilities, and equipment in the event of a civil emergency, including without limitations, natural or man-made disasters and disasters resulting from enemy action, and to provide for the coordination of disaster and emergency service functions of the borough with all other public agencies and affected private persons, corporations, and organizations. Simply put, if Petersburg is experiencing an emergency or disaster of such a magnitude that it may impact life or property within the borough limits, the borough government is responsible to assist the community and to access additional outside help if needed. That is actually quite common during a disaster to seek outside help. Petersburg needs to operate in a disaster by rules that are understood by other agencies. So we covered the ICS system very well, and those are the rules that I'm speaking of. The agencies that understand those rules are capable of providing financial assistance and resources. An ordinance such as the one being considered formally prepares the borough to respond and come to the aid of the population. It also firmly places Petersburg on the same playing field in using those same rules as other emergency management agencies. Namely, most importantly, the Department of Homeland Security and Emergency Management at the state level and FEMA at the federal level, as Sandy had covered. The use of the local civil emergency ordinance is brought about by actual circumstances that meet the definition of a disaster in a community. The specific ordinance that we're considering here has no authority for action by the manager or incident commander unless a civil emergency exists. However, the state recognizes the need for municipalities to provide for organized, pre-planned responses to disasters or civil emergencies and expects Petersburg to be compliant with the NIM system,
Sandy covered that very well. And to be ready to use the ICS system in the event of a disaster. The proposed ordinance lays out the basic structure of the response, but instead of codifying minute details regarding every possible disaster, which would be an enormous supplement to the code book, the ordinance appoints and authorizes an incident commander to oversee the response and refers to the disaster response plan as the guiding document that contains the details of that response. The incident command system is the language of emergency response, and its use leads to organization, collaboration, and cooperation between agencies in order to effectively address a disaster in a timely manner. In my view, by assigning an incident commander, the Civil Emergency Ordinance establishes the use of the incident command system in order to effectively respond to any local disaster emergency in a way that will address the problem quickly, but also qualify Petersburg for resource and financial assistance from state, and federal agencies. So how has the emergency ordinance helped with the current health emergency? I wanted to give some background, and again, this is some repetition on the ICS, but the incident command system is the basic rule book and playing field that all emergency response agencies understand, and using it facilitates discussion, cooperation, collaboration, and ultimately assistance with financial and resource needs during emergency response. It is important to note that the Assembly is ultimately in control of all borough actions, but it is impractical and inefficient to expect the elected body to convene and make decisions on a daily or hourly basis during an emergency. Since only a majority vote of the Assembly in a properly noticed public meeting can bind the borough to a course of action, this makes the prospect of the Assembly managing an emergency a very cumbersome undertaking. Instead, municipalities prepare in advance for the eventuality of a disaster or emergency and preordain who will be in charge if the need arises. In the proposed ordinance, the borough manager, who is the principal executive officer of the borough, is the designated incident commander for all emergencies or disasters. This is done so that decisions can be made efficiently and a response can begin or be changed quickly depending on developing situations. As proposed in the ordinance, the manager would also have the ability to assign an alternate incident commander with Assembly approval in circumstances that dictate a different skill set for the disaster lead, or if other circumstances prevent the manager from assuming the duties of the incident commander. While the purpose of the ordinance is not strictly focused on responding to a pandemic, the ongoing health emergency presented by COVID-19 is the most significant disaster that many Petersburg residents have ever dealt with. The temporary emergency ordinances that have been passed and subsequently extended during the pandemic has helped the borough respond to the threat and hazards presented by the coronavirus by providing the framework for leadership for the response. I've got a list of some actions and programs that have been born out of the Emergency Operations Center and Unified Command Team, which includes the borough and the medical center. And those actions and programs include formally establishing a relationship with FEMA and the Department of Homeland Security and Emergency Management at the state level in order to access disaster relief funds and supplies associated with common response tactics and resources. Receiving and reviewing a multitude of state-issued mandates and health alerts and sharing them with our public, providing the latest information that adherence to the law to Petersburg's population. Scheduling and participating in regular incident command meetings, both at the hospital level and borough level, to coordinate efforts and assign tasks and share knowledge regarding the evolving situation. At first, these meetings were daily, but as the situation stabilized and comfort levels rose with the defined course of action, the meeting schedule has decreased. These meetings allow for numerous local agencies to be represented, including the hospital, the borough, school, Chamber of Commerce, CDC, mental health, at times members of the Assembly. The command team also worked on receiving invitations to and attending countless State of Alaska video conference meetings regarding all manner of the statewide response, with access to top state medical, financial, and political personnel in order to further Petersburg's understanding of emergency and access assistance programs. We also worked on developing recommendations for local public health alerts and mandates to mitigate the potential and or actual spread of the virus in Petersburg. In other words, these are the mandates and health alerts, such as shelter-in-place mandates, face covering mandates, going to teleconference meetings, and the harbor access restrictions. We worked on developing a non-congregate sheltering plan and system in order to house homeless persons and healthcare workers who are waiting for COVID testing results or become infected, so that these people can be isolated and we can prevent the spread of the virus to others. There was support by the EOC for community-wide mask-making call to action and distribution of masks for those in need. We assigned an expert public information officer that put together a comprehensive public information campaign using common social media platforms to share the most current coronavirus information, including local testing and case information, infection prevention, federal, state, and local mandate and regulatory information, travel requirements, symptom information, financial assistance information, and public meeting access. We worked on development of asymptomatic testing programs in support of medical center, long-term care, Mountain View Manor, and other local populations. We worked with the local seafood processors in support of their COVID mitigation plans and coordinating an asymptomatic testing program for local workers. And I want to note that the processors in Petersburg should be recognized for their excellent plans that they put in place and followed through with all through the season that resulted in minimal virus infections and no work stoppages during the production season. We worked on development of traveler screening and testing services as required by the state of Alaska mandates. Also, the development of local financial assistance programs, including nonprofit assistance, federal application assistance, small business support, child care assistance, and utility assistance programs. We focused outreach to visitor industry businesses to inform and collaborate on the preparation and response to potentially infected visitors entering the community. We reviewed We worked on a review of transit business mitigation plans, as well as access to cruise industry contacts and review of cruise boat operations and mitigation plans. And finally, we were in the process of developing a community-based protective plan to inform residents of recommended actions for self-protection based on the ongoing situational awareness of the virus in Petersburg. All those actions were born out of the EOC and use of the Incident Command System that was paved by the emergency ordinance. So the Federal Emergency Ordinance provides the overriding structure for the Incident Command team to perform these duties in support of the pandemic response. However, when looking at the need for a permanent civil emergency ordinance, the community must look past the current public health emergency and understand that the ordinance will be helpful in responding to all manner of emergency in the future. The Borough Management and Assembly need to have the structure at the ready in order to respond to large emergencies such as a fire, landslide, tidal wave, flood, earthquake, and so on. The Borough does not have the option of not responding to an emergency or disaster. With that in mind, preparation is the key to an effective response that may save someone's life or property, and this starts with a codified emergency ordinance. Every emergency management decision is born from the responsibility to protect life and property, as mentioned by Sandy, and in support of our community. There is no need to do any more than necessary to protect our citizens and handle emergency or disaster as quickly as possible. The ordinance requires that any orders are to be designed to be the least restrictive as possible when seeking to protect life and property, as Sarah Heidemann mentioned. With that being said, it is natural for Americans and Alaskans to question authority and second-guess the actions of the government, including the President, Governor, Assembly, Manager, and Incident Commander, whether those actions are in their own best interest. To mitigate those questions, the focus of leadership in the face of a disaster must be just wide enough to encompass all known hazardous conditions, to anticipate the next potential problem, to define and carry out solutions, and to return normalcy once the emergency is over. The responsibility to lead, make good decisions, and help others in the face of disaster weighs heavily on those that have been given that role. Excuse me. The Assembly has put people in place to help navigate our way through the pandemic. But know that the major decisions have ultimately fallen to our elected leaders, regardless of what powers were granted to the manager or incident commander in the temporary emergency ordinances. The incident command team understands this, accepts this, and has tried to build a relationship of trust and cooperation with the elected body and the community. Yet, we know that it is impossible to make everyone happy. For every person who claims invisible overreach, there is another that is urging to reach further in pursuit of public health and safety. Hearing and managing the desires and opinions of all residents is part of a public sector job. But the responsibility to keep the population safe must be taken seriously and requires that response actions fall on the side of caution as much as possible. A civil emergency ordinance does set the table for a quick, cautious, and successful response when called for, and should be part of the municipal code on a permanent basis. And that's my presentation, Sarah. I'll hand it back to you.
Thank you, Carl. That wraps up our presentations. Next is stage 2, and I will give a reading of the Q&A document, the questions received in advance of this meeting with the prepared responses. There are 7 questions and 7 answers. Question 1 was submitted by Brian Lynch. I wish to request that the borough attorney be made available during the September 10th meeting to address a specific legal issue within the proposed amendments to Petersburg Borough Code, Chapter 3.72. Specifically, Section 3.72.060A3 prohibit gatherings of persons in excess of a specified number in relation to church services. The Petersburg Ministerial Association has testified, as have others, that this section violates the First Amendment to the United States Constitution. I wish to have the attorney address this concern and to specifically discuss the compelling governmental interest test and the associated scrutiny that would be applicable to this section and why, in the case of a civil emergency, restrictions on public gatherings, including church services, would not necessarily violate the First Amendment. The reply to question 1 is, the United States Supreme Court, over 115 years ago in the case of Jacobson v. Massachusetts, held that constitutional rights may be reasonably restricted to combat a public health emergency. Jacobson addressed a law enacted to combat an outbreak of smallpox, and the court upheld the law, stating that, quote, the liberty secured by the Constitution of the United States to every person within its jurisdiction does not import an absolute right in each person to be, at all times and in all circumstances, wholly free from restraint, end quote. Communities have the right to protect themselves against epidemics which threaten their residents, and individual rights may at times, quote, be subjected to such restraint to be enforced by reasonable regulations, as the safety of the general public may demand, end quote. Under Jacobson, emergency measures may be implemented so long as the measures bear some real or substantial relationship to the public health crisis and do not represent a, quote, plain or palpable invasion of a clearly protected right. This test was applied recently in a case brought in California against the shelter-in-place orders issued in response to the coronavirus pandemic. The plaintiffs there asserted that the orders violated their right to the free exercise of religion under the First Amendment of the United States Constitution. The court there held that the orders met the test set out in Jacobson. The restrictions were intended to slow the spread of a virus and thus had a substantial relationship to the COVID-19 pandemic. And the orders did not invade the plaintiffs' free exercise of religion, as while they were unable to gather together in person, they could freely practice their religion by other means, including gathering virtually or by telephone or practicing with other members of their household. The court in that case also held that a higher standard of constitutional scrutiny was met, the rational basis review. This is the test that generally applies to laws that are neutral in their wording and are generally applicable. Under that review, a government must demonstrate that the order is rationally related to a legitimate governmental interest. The court found that the orders were neutral on their face. They did not make reference to or discriminate against any particular religious practice or belief. and were neutral in their application. They applied to both religious and secular conduct in an equitable and reasonable way. The court held that the shelter-in-place restrictions were rationally related to the legitimate interest in slowing the spread of COVID-19, and thus could be upheld on that basis. The highest standard of judicial review is known as strict scrutiny. This would apply to laws that were not neutral or not generally applicable. In other words, the law in some fashion applies to religious beliefs or practices in a manner that is discriminatory or inapplicable to other non-religious conduct. In those cases, the governmental entity would be required to demonstrate a compelling governmental interest in order to uphold the law. How does this discussion apply to proposed Ordinance 2020-19, specifically Section 3.72.060A3? That provision allows the Borough, by emergency order, to prohibit gatherings of persons in excess of a specified number. This could obviously impact the gathering together of individuals for many purposes, including for religious practice. Such an order would be subject to judicial review as outlined above. To protect both individual rights and the public at large, the Borough should ensure that such a gathering restriction relates to the emergency at hand and operates in an equitable and reasonable manner to both religious and non-religious activity. So, in short, while the individual constitutional rights do not disappear during a public health crisis, it is well established that those rights can be reasonably restricted. Those restrictions, however, must be related to and directed at the public health crisis and be non-discriminatory. Question 2 was submitted by Jeff Mucci. Will adopting this ordinance permanently change life as we know it in Petersburg? The reply to question 2: no, life will not change. However, in the event of another emergency or the extension of federal, state, and local health mandates or actions related to disasters, the framework would be in place to ensure that procedures and safeguards are followed by the Borough Assembly and staff while acting in a manner consistent with providing for public health and safety. The ordinance at its core allows the Borough to respond to a local emergency in a prescribed fashion. The provisions or prescriptions are not used unless there is an emergency declaration required in Petersburg. Therefore, normal everyday life in Petersburg is unaffected by the ordinance. It is only in times of disaster or emergency when the ordinance could be utilized in order to systemically address the need for public health and safety protections in the preservation of life and property. Having an organized and pre-planned system for addressing emergencies and disasters is a core function of a local government. Question 3, submitted by Jeff Mucci. Since we have had the emergency ordinance in effect for the past few months, have we closed any businesses, imposed any curfews, prohibited any gatherings, or evacuated persons from designated areas? Reply. In the early days of the pandemic, the Assembly passed Public Health Mandate No. 1, which directed folks to shelter in place as much as possible and closed certain non-essential businesses. That health mandate was almost immediately overtaken by numerous state health orders, and the borough's health mandate expired about 14 days after it was enacted, on April 9th. Since that date, no further local orders have been issued that closed non-essential businesses. No local evacuation or curfews have been issued, nor orders limiting the number of persons in a single gathering. Question 4, submitted by Jeff Mucci. If Ordinance 2020-19 is passed in its third reading, will the Borough Assembly have the final say on all matters under the ordinance? Reply. Yes. As drafted, the Assembly has the final say on all emergency response matters. This has been the practice throughout the current health emergency. The ordinance does allow for certain actions to be initiated by the manager or the incident commander. These actions would be required under a fast-moving and exigent circumstance when it is impractical or impossible to first convene an assembly meeting to receive direction from the elected body. These more pressing actions could include evacuation of a specified area, closure of a road or area to travel in the case of a danger caused by an earthquake or tsunami, and other provisions not listed but that might be needed to immediately protect life and property. However, all actions by borough staff in the protection of life and property can be quickly removed, canceled, or modified by the Assembly once it meets and considers the conditions and situational hazards presented by the particular emergency or disaster that has arisen. Question 5, submitted by Jeff Mucci. Does the borough already have the authority to issue emergency orders and mandates as set out in Draft Ordinance 2020-19? Reply, yes. The authority of the borough to both adopt this ordinance and issue emergency health mandates is based on its status as a home rule borough and on its police powers. Accordingly, the borough has authority to enact public health measures provided that those measures do not violate its own home rule charter or impermissibly conflict with federal or state law. Under the Alaska Constitution, Article 10, Section 11, home rule cities and boroughs like Petersburg can exercise, quote, all legislative powers not prohibited by law or by charter, end quote. This same provision is repeated in Alaska statute at Section 29.04.010. The Alaska Constitution specifically intended to provide for, quote, maximum local self-government. That's from Article 10, Section 1, without traditional restrictions on the local exercise of powers. Additionally, the borough possesses what are known as police powers. This, as Sarah Heidemann said, does not relate to the police department, but is the term that has been used by courts for over 100 years to refer to the fundamental right of a state or local government to make laws necessary to protect the welfare, safety, and health of the public in cases where that right was not retained by the federal government. Adopting the emergency health and safety measures found in this ordinance would be permissible under the borough's police powers. State statutes addressing emergencies are found in the Alaska Disaster Act. You can find that at Alaska Statute 26.23.010 through 26.23.240. No provision of this proposed ordinance conflicts with those statutes. Under Alaska Statute 26.23.060, each city and borough of the state is primarily responsible for its own disaster preparedness and coordination. Question 6, submitted by Jeff Mucci. If the borough already has the authority to issue emergency orders, why is the update to the code needed? Reply. The current version of Chapter 3.72 was adopted by the then city some 15 years ago, and it needs to be brought current in certain aspects. In addition to changing city to borough, the proposed revisions update the chapter to use the broader term of emergencies as defined by Alaska statutes, specifically the Alaska Disaster Act. Second, it is important for the code to refer to the authority of the borough manager to issue an emergency proclamation under Alaska Statute 26.23.140. While that authority is already found in the state statute, you have to know to look for it in there. It is much more straightforward for it to be set out in the local code book that is more familiar to staff and to residents. Third, the current code language does not have any procedures or safeguards in place for enactment of emergency health and safety orders like those that have been issued by both the state and the borough during the current pandemic. While the borough has the authority to issue health alerts and mandates, adding language regarding issuance of orders provides guidance for both the Assembly and for residents. The proposed changes to the chapter set out who can issue the orders, who can terminate the orders, the subject of the orders, and they also provide safeguards when rights are going to be temporarily restricted. Under Section 3.72.060B, an order is required to state the known facts upon which the order is issued. It has to contain a statement that the order is found to be in the best interests of public health and safety, and thus the situation requires a temporary restriction on rights, and the order must indicate that the measures are being implemented with the least restrictive means available or possible. So while it is well established that certain rights can be temporarily restricted in the case of public emergencies, the intent of this section is to ensure that those measures are being taken by the least restrictive means. Fourth, Chapter 3.72 should include language clarifying that orders issued would supersede other conflicting borough ordinances, so there is no ambiguity. That language is not in the current chapter. And lastly, it is important to update the code language as to violations. Existing Code Section 3.72.040 currently establishes interference with emergency services as a misdemeanor. The borough has been transitioning for the last several years to having violations of the code be primarily minor offenses, not criminal misdemeanors. If charged as a borough misdemeanor versus a state misdemeanor, of course, the borough would have the obligation to both prosecute the case and to provide the defendant, at the borough's expense, an attorney if he or she cannot afford one. To reiterate, the borough has the authority to enact public health measures either under the current language of Chapter 3.72 or the proposed revised version. However, the updated chapter would provide a clear framework for responding to emergencies by including both procedures and safeguards, and ensure that there is specificity and transparency in the process. Updating Chapter 3.72 will provide the public easy access to what they may expect from the borough in the event of a disaster or emergency. The final question was submitted by Marjorie Oines. Request for addition to the Petersburg Borough Ordinance 2020-19 as follows. Whereas it is understood that the police and borough officials are not able to fully protect all residents in the borough, the following addition can be placed under 3.72.060A as number 2, then move the other numbers to the next sequence. As an assurance to our residents, they are given the responsibility and right to protect themselves and their property. It also assures residents that items residents use to protect themselves will not be confiscated from their homes. Reply. The right to bear arms in defense of self or others is specifically guaranteed under the Alaska Constitution, Article 1, Section 19, and the authority to regulate firearms has been specifically reserved to the state of Alaska. Municipalities, like Petersburg, including home rule municipalities, are very limited in what they are allowed to enact. Generally, municipal firearms laws must be identical to state laws. If there is a concern that the borough would seize firearms in the event of an emergency, this is also specifically addressed in state statute, where it provides that nothing in the Disaster Act, quote, authorizes the confiscation of a firearm lawfully owned, possessed, or carried by a law-abiding citizen. Alaska Statute 26.23.200. Finally, it's stage 3. It's the time for the Petersburg community to give comments and ask questions about proposed ordinance 2020-19. To make things simple, the same rules apply this evening as for making a public comment at a borough assembly meeting, so a 5-minute time limit, no lewd comments or personal attacks, but otherwise, ask away and comment away. Clerk Thompson, how many people do we have on the line?
We have one public speaker.
One public speaker. You may go ahead, caller.
That's not possible. Is that me?
Yes.
Janice? Okay. Here we go. Some assembly members have stated, what's wrong with the new ordinance? It really isn't much different than the old ordinance. That's true, but very few people in Petersburg realized how badly we were set up with the old one. Both ordinances allow enormous overreach by the public sector. When you're not paying attention, the stealing of liberty can begin quietly and then suddenly escalate, as we have seen in the last 6 months. There seems to be an assumption that we, the people, are too ignorant to understand the finer points of government control, and that if only things are explained to us slowly and carefully, at last we will understand and acquiesce. But it is some of the Borough Assembly who are ignorant of history and ignorant of human nature. Totalitarian governments can come about through legal means and quickly. People forget that that Adolf Hitler never stole an election. Hitler was elected legally by a vote of the people. That legal election led to the nightmare of World War II and the Holocaust. Before him and his unscrupulous ways, the Germans' laws had worked well enough, but he found ways to twist the law to his desired ends. Therefore, because of human nature, it should be more difficult for stringent measures to be imposed on the public, not less difficult. For example, who gets to decide what is an emergency? An emergency indicates that there is no time to follow ordinary procedures due to an acute, immediate crisis. Well, we already have the fire department, the EMTs, the police, the state troopers, who all know their jobs well. But what about an emergency that goes on and on and on? Is that an emergency? Is that a temporary restriction of rights? In this scenario, what if a group is running a show who will not listen to their constituents? There has to be a place in the law for public input and for public sector accountability. I'm not saying those things in this emergency ordinance. We've had plenty of time here in Alaska to observe that there is no emergency, but our public health sector doesn't seem to care. They are carrying on. But by the CDC's own most recent reckoning, COVID-19 deaths are not really over 160,000, but a mere 6% of that number, less than seasonal flu in some years. To a hammer, everything looks like a nail. To the public health officials directing the opening and closing of our society, every person looks like a case of walking black death, even though they don't have symptoms. There has to be a place, a large place, for public input. Thank you. I'm Dana Tinas.
Thank you for your testimony. It sounds like we have another caller on the line. Rob Schwartz, you may go ahead.
It's Rob Schwartz, Petersburg resident. Anyway, I've been reading through this ordinance over and over again and talking with quite a few people in the public. It's shocking to us. You know, we talk about things being based on facts. Well, I've been trying to get facts about COVID-19 since March. You know, you read one PhD who has 25 years in virology, and he says one thing, and then you read another guy who's got 2 PhDs, and he says exactly the opposite. The facts are pretty gray. A lot of opinions. Dana was mentioning what the CDC came out with recently. We also had something on July 21st. We don't really have any evidence that face masks work, help, harm, whatever. But I'm reading through this, and it's always been a question of, do we give up our rights in the name of security? Well, a tsunami ends, a fire ends, or an earthquake ends. We've been dealing with this for 6 months. You know, you should say that life isn't going to change. It's disrupted everything. It's disrupted our churches. It's disrupted our work, our businesses. It's just disrupted our families, you know. And so this goes on and on and on. Who's going to say, okay, the pandemic's over? Thank God it's over. And you're asking us to trust you and your opinion or your evaluation of quote-unquote facts. I've been listening to Fauci since March. He's contradicted himself over and over again. So anyway, bringing in outside law enforcement, closing businesses down, not allowing us to drive our vehicles. If we have an emergency in my family somewhere, I'm responsible for my safety and my family's safety. So just get ready, because I will not comply with this ordinance. And neither will most of my friends. They won't comply with this. So the courts will be packed, and you can pack the jail rooms, whatever you need to do. But as far as we're concerned, and there's a lot of us, we think this is absolute BS. Thank you for your time.
Thank you for your testimony. Our next caller is Nicholas Burns. You may go ahead.
Hi there.
Hi.
Okay. I would like to second the comments made by the first two individuals. I believe everything that they've had to share. And I would also like to point out that in my past I have researched, been required to understand the MIM system, the ICS system, I've written for the presidential emergency response programs a response in accordance with those rules. You have not provided a plan. These ordinance instructions are not that. You have allowed for authority to essentially reign over individuals. It does not define a distinct and flexible course of action that requires an emergency response. An emergency does require that you take action. You have relieved yourself of liability. You have, with layers of law, covered up the fact that you can fail. You have no idea how fragile the system is, period. The reason that a local government can have the authority, can have the home rule effect, is that you can make fast and accurate decisions for your group of people. We have not allowed that. I'm leaving this down. I have voted with my pocketbook. I have voted with my ability to leave. That is my privilege in the United States. I, for one, would never allow myself to come under the terms of this ordinance. I also know from my background in law enforcement, federal law enforcement, and military service, that you cannot enforce this rule. I have enough knowledge that you have a lawyer who's paid very well to defend your terms, and at the end of the day is meaningless. Good luck with that. I understand you're going to vote for it probably anyway, but understand that there are people, especially in Alaska, who do not have to understand those terms and accept them, because at the end of the day, it is a people's rule. And the rule of law at least gives them that right. Thank you.
Thank you for your testimony. Clerk Thompson, are there any other callers?
There are not.
Well, that was our last caller. Thank you to all who tuned in, called in, and gave presentations this evening. This is democracy at work. It's tough work, but well worth the effort. Be well, Petersburg. Back to you, Mayor Jensen.
Thank you, Sarah, and thank everyone for that good presentation and for the callers that called in. I would like to remind everybody that the reading, the third and final reading of this ordinance is September 21st, 6 p.m.
Wrong fucking thing.
Someone else is talking here, but anyway, call in. There's a room on the agenda for views related to the items on the agenda. And have a good evening. And with that, we will close this community discussion. Thank you.